Having analyzed the evidence before the trial chamber, the appeals chamber considered that, although witness 1 was not the victim of an intentional act or omission causing serious physical suffering or injury, his treatment caused him serious mental suffering and constituted a serious attack upon the human dignity of witness 1, who was incapacitated in a well and separated from his wife, who was now in the hands of armed KLA soldiers. The appeals chamber therefore granted the prosecution's ground of appeal in part and reversed the finding of the trial chamber that the treatment of witness 1 did not constitute cruel treatment. However, although the prosecution proved that the KLA soldiers committed cruel treatment against witness 1, it did not prove that Mr. Balaj was responsible for it under the modes of liability charged by the prosecution. The appeals chamber therefore upheld Mr. Balaj's acquittal on this count. I now turn to Lahi Brahimaj's 19 grounds of appeal, in which he requested the appeals chamber to reverse his convictions in relation to the torture and cruel treatment of witness 6 and witness 3, and in which he challenges his sentence. In grounds of appeal 1 and 2, he alleged that the trial chamber committed numerous errors relating to its findings that he was responsible for the torture of witness 6. For the detailed reasons set forth in the written judgment, the appeals chamber has dismissed these grounds of appeal. In grounds of appeal 3 through 8, Mr. Brahimaj lodged a multitude of challenges to the trial chamber's findings that he was responsible for the torture and cruel treatment of witness 3. For the detailed reasons set forth in the written judgment, the appeals chamber has dismissed these grounds of appeal. In ground of appeal 9, Mr. Brahimaj submitted that the trial chamber erred in its findings with respect to his conviction for the torture of witness 3 on the basis that the prosecution failed to prove that any of the motivations behind the mistreatment of witness 3 were necessary for torture conviction. The appeals chambers held that the prosecution failed to plead the material facts for one of the bases that underlay the torture conviction, and that the trial chamber therefore erred in this regard because Mr. Brahimaj was not given proper notice of this basis for his torture conviction. However, because the trial chamber convicted Mr. Brahimaj for torture on more than one basis, his conviction for the torture of witness 3 still stands. In grounds of appeal 10 through 19, Mr. Brahimaj submitted that the trial chamber made numerous errors in determining his sentence of 6 years of imprisonment. For the detailed reasons set forth in the written judgment, the appeals chamber has dismissed all of these grounds of appeal and has affirmed Mr. Brahimaj's sentence. I am now going to read in full the disposition of the judgment of the appeals chamber. May I ask Mr. Haradinaj and Mr. Brahimaj to stand. For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the Statute of the Tribunal and Rules 117 and 118 of the Rules of Procedure and Evidence of the Tribunal, noting the respective written submissions of the parties and the arguments they presented at the appeal hearing on the 28th of October, 2009, in respect to the prosecution's appeal, grants prosecution ground of appeal 1, Judge Robinson dissenting, and quashes the trial chamber's decisions to A. Acquit Ramush Haradinaj and Idriz Balaj of participation in a joint criminal enterprise to commit crimes at the KLA headquarters and the prisons in Jablanitsa under counts 24, 26, 28, 30, 32, and 34 of the indictment. B. Acquit Lahi Brahimaj of participation in a joint criminal enterprise to commit crimes at the KLA headquarters and the prison in Jablanitsa under counts 24, 26, 30, and 34 of the indictment. C. To acquit Ramush Haradinaj, Idriz Balaj, and Lahi Brahimaj of individual criminal responsibility under counts 24 and 34 of the indictment, and D. To acquit Lahi Brahimaj of individual criminal responsibility under count 26 of the indictment, and orders that Ramush Haradinaj, Idriz Balaj, and Lahi Brahimaj be retried on these counts. Dismisses prosecution ground of appeal 2. Grants in part and dismisses in part prosecution ground of appeal 3 and affirms Idriz Balaj's acquittal under count 37. In respect of Lahi Brahimaj's appeal, dismisses Lahi Brahimaj's grounds of appeal 1 to 8, grants in part and dismisses in part Lahi Brahimaj's ground of appeal 9 and affirms Lahi Brahimaj's conviction under count 28. Dismisses Lahi Brahimaj's grounds of appeal 10 to 19, affirms Lahi Brahimaj's sentence, and pursuant to Rule 64 and Rule 107 of the rules, orders the detention on remand of Ramush Haradinaj, Idriz Balaj, and Lahi Brahimaj, and enjoins the commanding officer of the United Nations Detention Unit in The Hague to detain them until further order. I have appended a partially dissenting opinion to the judgment in respect of the majority's findings relating to the prosecution's first ground of appeal. You may now be seated. The appeals chamber hereby lifts the confidentiality of the arrest warrant for Mr. Haradinaj, which was issued on the 19th of July, 2010. Copies of the judgment will be delivered to the parties after this hearing. The hearing is adjourned.
All rise, veuillez vous lever.